And welcome to our next two, well, we only have three more of these to go. So we're getting really close. Hang in there with me. Today we're going to be talking about the criminal justice system and the judiciary, justice, the federal court system. So let's get started with our grand history of courts. And if we go back through history, we have a grand tradition of courts throughout our history. The first one being the Code of Hammurabi, first written law from Babylon, introduced the idea of law as justice. The idea of law could be used to right a wrong. It was followed by Mosaic law, which introduced the idea of innocence, and therefore you had to have a court and mercy. Under the Code of Hammurabi, if you wronged someone, they killed you. If you were rich and you wronged someone, you had to pay a lot of money. Under Mosaic law, it was actually an idea of mercy. The punishment should only be as harsh as the crime. So if you knocked out someone's eye, you should have your eye knocked out. Whereas under the Code of Hammurabi, if you knocked out someone's eye, you should be killed. So Mosaic law actually represents a movement towards mercy, and the idea of law is mercy. And here we get our two major themes that we start to have. We'll add one more to this, but these are our two major themes as we look at all the law. Law is justice, law is mercy, and then one more that we'll get to in a minute. Greek law introduced the idea of a jury of peers and commoners. Roman law introduced the idea of codifying law and writing it down. And therefore they introduced the idea of law as being something that is constant, immutable, always there, never changing. However, none of these sets of laws actually survived the fall of Rome. I know it's a big thing with conservatives to say, our law goes back to the Old Testament Mosaic law. It actually doesn't, and here's the reason why. You see, none of these codes of law actually survived the Visigoths. The Visigoths and other Germanic tribes renounced the idea of trial by ordeal or trial by combat. And so, it's not renounced, reintroduced the idea of trial by ordeal or trial by combat. The Visigoths were a barbarian tribe, a Germanic tribe in Europe. They came through and they go through all of the ancient world pretty much, and they just annihilate all the systems, all the codes of justice that we see in Western Europe. And they replace them with the idea of a trial by ordeal or a trial by combat. The reason they do this is because Goths have lots of people who are well armed and need entertainment. And what better way than entertaining them than letting two people have a disagreement fight it out? After all, they used knives, it was bloody, and people would get a lot of entertainment out of watching these things. And that brings up this new idea, this third theme, the idea of law as something that entertains people. But this changed in the Middle Ages with the occurrence of the Black Death. Why? If you lose 2/3 of your population, you don't have enough population to actually let people fight it out anymore. So now what do? Well, they went to trial by lord. Now you go to your local lord and you have a trial. Lord charges you to have the trial. He'd ask for a fee from each one of you, and then he would settle your disputes. The problem with this is who would win? Well, it depends. Who gave the biggest bribe to the lord? And what if you were from a different lord's territory? Well, let's say, for example, you bought a plow in exchange for a cow from my blacksmith. My blacksmith took the payment but never actually gave the plow to you. He still has it. And you come to me complaining about this. Why would I want to give you the plow? If I give you the plow, I no longer have a plow because everything that's the blacksmith's is also mine. So why would I rule in favor of anyone who is from someone else's territory? And if you could always be taken advantage of, why would you trade? No, this type of justice actually kept economies very, very small. However, the War of the Roses in England changes this. Law courts were required by Henry II to have common rulings long before the War of Roses, but the courts were appointed and maintained by local lords. Thus, they had the same problems as trial by lord. Henry VII changes this because he needs more than anything else in the world, money. Henry's court was better than other courts for two reasons. The court was required to be fair, or else the judge would die. The court was cheap. It charged a flat fee to hear the case from both sides. To make sure that they kept this, judges started to meet together in London to discuss their cases at Lincoln's Inn. the inn of the inner temple, the inn of the outer temple, and Gray's Inn. Here they would talk about their cases and discuss them at the bar. By the way, this is why the Association of Lawyers is still known as the Bar Association in the first place. It actually goes back to the bars of these inns where the judges would actually meet to discuss their cases. The idea of precedence, that you could do something because someone else has done it, actually comes from these discussions. So in other words, if you do it once, you can do it again. And this is the development of the common law system. So what are the effects of these courts? England can now trade with itself, because if you are a person from a different lord's territory, you can go to one of these courts from Henry and get justice. You can get fair treatment. And so a middle class of artisans grows and prospers. England therefore becomes the wealthiest nation in the world because of this, and world power by the time of Elizabeth, all because courts were reformed. Spain had to conquer a new continent to become a world power. England did it by trading with Spain. This brings us to the U.S. The Founding Fathers did not know what they wanted the courts to do, but they knew they wanted the economic development the courts would bring. And you can tell this if you read the Constitution. Article 3 is only 2 paragraphs long, and they're very, very short paragraphs. So if the judiciary doesn't get its power from the Constitution, where does it get its power from? Primarily, it gets its power from Mayberry versus Madison. Mayberry was a person who was part of John Adams' political party, and he was supposed to be appointed by Adams, but Adams never got to make the appointment. He intended to, and was actually in the process of signing Mayberry's appointment, and the clock struck midnight. On the eve of Adams' presidency, he literally was not president by the time that he finished the signature. One of Madison's advisors took it up, tore it in half, and said, "I'm sorry, Mr. President, but your time is up." Mayberry sues Madison because he says, Adams intended to make me a judge, therefore I should be a judge. Congress supported Mayberry because they were from the political party that Adams was a part of. However, Madison was the president. Mayberry sued Madison. Madison said to the John Marshall, the Supreme Court Chief Justice, "John, you don't have enough judges right now. I'll make this simple for you. If you rule against me, I will never nominate another judge to the bench, and the judiciary will collapse." Congress went to Marshall and said, "John, I will make this very easy on you. If you don't rule in favor of Mayberry, we will not confirm a single judge that Madison presents to us, and the judiciary will fall apart." Marshall was he was in a rock and a hard spot. And so he made the only rule that he could. It's my ball, and I'm going home. Marshall said, "I have looked at the Constitution, and nowhere in the Constitution does it say that I have the power to make this ruling. So I'm not going to. You work it out in yourselves." But remember, according to common law, if you do something once, you can do it again. Because Marshall had gone through and looked at the Constitution to make his ruling, he was free to look at the Constitution and make his ruling from that point on to determine whether or not any other branch of government was doing something according to the Constitution. All of the power of the Constitution comes from the fact that it is a common law court and that it made this ruling with Mayberry versus Madison. So let's look at the Chief Justices and how they've shaped the court. And since all of the powers of the court come from these rulings, let's look at the rulings that give the court its sway today. So first of all, we start with the Jay Court, led by John Jay. West versus Bond, court cases have to be filed with the Supreme Court clerk and not with state clerks. Hayburn's case, could Congress give non-judicial duties to federal courts? They didn't rule an issue to that. Georgia versus Brailford, jury nullification. A jury has the right to hold the law as null and void. Judges don't like it when you do that. The Rutledge Court, United States versus Peters. The U.S. has no jurisdiction over foreign privateers. Talbot versus Jansen. Citizenship extends to overseas, and citizenship still exists if you deny your state citizenship or if you also become a citizen of another country. Hilton versus the United States. The United States has the authority to tax goods and service. This is our third Supreme Court Justice, Ellsworth. Hollingsworth versus Virginia. The President has no formal role in amending the Constitution. Carter versus Bull. This one had actually 4 major propositions. Ex post facto only applies to criminal cases, not to civil cases. 2, the federal courts have no authority to determine if a state violates its own constitution. 3, you can't make someone do something that's not required by law. And 4, you cannot bring a suit unless the law directly affects you. Then we have the Marshall Court. Here we have Mayberry versus Madison, the court that has the right to determine constitutionality. Fletcher versus Peck, the court can invalidate state laws that are contrary to the Constitution. McCullough versus Maryland, Congress has implied powers through the Necessary and Proper Clause, and states cannot impede the federal government. Collins versus Virginia, the court can overrule state court decisions. Givens versus Ogden, the power to regulate interstate commerce also gives the power to regulate interstate travel. Johnson's versus McIntosh, the Cherokee Nation versus Georgia, and Worcester versus Georgia. Native Americans are not citizens, thus they do not have natural rights, including the right to property. Dartmouth College versus Woodard. Corporations are private citizens and thus have all the rights of people. Barron versus Baltimore. The Bill of Rights does not apply to the states. Me McQueen versus John Hepburn. Hearsay is not permissible evidence in court. The Tanley Court. We have the Charles River Bridge versus the Warren Bridge. Private property rights must take into account the rights of the nation and the community. Briscoe versus the Commonwealth Bank of Kentucky. Banknotes are constitutional. The Mayor of the City of New York versus Milton. State regulations of commerce can be stronger than national regulations. Prigg versus Pennsylvania. States could not prevent the return of slaves to their masters. Luther versus Borden. Whether a state government is legitimate Republican form as guaranteed by the Constitution is a political question to be resolved by the President and Congress and no one else. Genesee Chief versus Fitzhugh. U.S. has authority over the Great Lakes and other navigable waters. Dred Scott versus Stanford. This one actually had 3 parts. Persons of African descent cannot be, nor will ever be intended to be, citizens under the U.S. Constitution. The plaintiff was outstanding to file for a suit. The property clause is only applicable to lands possessed by the time of ratification. As such, Congress cannot ban slavery in the territories. 3. Due process clause of the Fifth Amendment prevents slaves from being freed by the federal government in U.S. territories. This sided with the South and saw the court system almost dismantled under Lincoln. Then we have the Chase Court, Texas versus White. Because secession is illegal, Texas actually never left the Union. However, Texas is still responsible for paying off its war debt. Benzie Banks versus Fino. Congress has the authority to tax banks and business. Hepburn versus Griswold. Paper money was unconstitutional. It was actually overruled later in 1871. Slaughterhouse cases. The privileges and immunities of citizenship in the United States were to be protected by the 14th Amendment, not privileges and immunities of citizenship of a state. We have the Waite Court. The United States versus Krishek. The First Amendment right to assembly was not intended to limit the powers of state governments in respect to their own citizens, and the Second Amendment has no other effect than to restrict the powers of the national government. Minor versus Happersett. The 14th Amendment does not guarantee the right for women to vote. Munn versus Illinois. The 14th Amendment does not prevent a state of Illinois from regulating charges for use of a business's grain elevators. United States versus Harris. Local, not federal government has the power to penalize crimes such as assault and murder. Santa Clara County versus Southern Pacific Railroad Company. Railroad corporations are persons within the intended meaning of the 14th Amendment of the United States Constitution. The Fuller Court. Caldwell versus Texas. No state can deprive people of equal justice under the law. Plessy versus Ferguson. Separate and equal facilities are allowed. Pollock versus Farmers Loan and Trust Company. The unappropriated income taxes on interest, dividends, and rents imposed by the Income Tax Act of 1894 were, in effect, direct taxes and were unconstitutional because they violated the rule that direct taxes can be appropriated. So Congress had to pass an amendment so that we could have income taxes. The United States versus the E.C. Knight Company. Manufacturing is not considered an area that can be regulated by Congress pursuant to the Commerce Clause. We have the White Court. Ginn versus the United States. A state statute drafted in such a way as to serve no rational purpose other than to disadvantage the right of African American citizens to vote violates the 15th Amendment. The selective draft law cases upheld the legality of the military draft. We have the Taft Court. Balzac versus Puerto Rico. It was a ruling that people in the overseas territories were not protected by the 14th Amendment. Bailey versus Drexel Furniture Company, holding the 1919 child labor law unconstitutional. Myers versus the United States, ruling that the President of the United States has the power to unilaterally dismiss executive branch appointees who have been confirmed by the Senate. The Hughes Court. Neer versus Minnesota. A Minnesota law that imposed permanent injunctions against the publication of newspapers with malicious, scandalous, and defamatory content violated the First Amendment as applied by the states of the 14th. Minnesota Supreme Court reversed their decision. United States versus Butler. The Agriculture Adjustment Act is unconstitutional exercise of power. This is an anti-New Deal ruling. Carter versus the Carter Coal Company. The court found that the Coal Conservation Act is not within Congress's power according to the Commerce Clause. Just because a commodity will in the future be sold in interstate commerce does not give Congress the right to regulate it before the event occurs. West Coast Hotel versus Parrish. Washington's minimum wage law for women was valid regulation of the right to contract freely because of the state's special interest in protecting their health and ability to support themselves. Supreme Court of Washington affirmed this decision. Schletcher Poultry Group versus the United States. Section 3 of the National Cheek Clapping Recovery Act was unconstitutional delegation of legislative power to the executive. It was not a valid exercise of congressional commerce power. Second Circuit Court of Appeals affirmed in part and reversed in part. The Stone Court. Ex parte Quirin. The court upheld jurisdiction for the United States Military Tribunal over his trial of several German saboteurs in the United States. The International Shoe Company versus Washington. Suit cannot be brought against an individual unless they have minimum contact with the forum state, and as such lawsuit does not offend traditional notions of fair play and substantial justice. The Vinson Court. Youngstown Sheet and Tube Company versus Sawyer. The President did not have inherent authority to seize private property in the absence of either specific enumerated authority under Article 2 of the Constitution or statutory authority conferred by him by Congress. Sweat, Painter, and McLaurin versus Oklahoma State Regents. The Equal Protection Clause of the 14th Amendment requires a petitioner to be admitted to school and be treated fairly in school. Warren Court. Brown versus the Board of Education. Separate is not equal. Baker versus Carr and Reynolds versus Strims. Redistricting is not a political question, thus the courts can oversee it and representation must be based on population. Gideon versus Rainwhite. Government must provide attorneys if you cannot afford one. Miranda versus Arizona. Government must tell you your rights before your arrest. Mapp versus Ohio. Prosecutors cannot use evidence found in illegal searches. Terry versus Ohio. Police can search you for weapons without a warrant. Engel versus Fatale. Government-directed prayer in public schools violates the Establishment Clause of the First Amendment, even if the prayer is denominationally neutral, and students may remain silent or be excused from the classroom during its recitation. Griswold versus Connecticut. A Connecticut law criminalizing the use of contraceptives violates the right to marital privacy. Then we have the Berger Court. Swan versus Charlotte Mecklenburg Board of Education. Busing students to promote integration is constitutional. The United States versus U.S. District Court. The court held that government officials were obligated to obtain a warrant before beginning electronic surveillance, even if domestic security issues were involved. Furman versus Georgia. The arbitrary, inconsistent imposition of the death penalty violates the 8th and 14th Amendments. It constitutes cruel and unusual punishment. Roe versus Wade. A Texas law making it a crime to assist a woman to get an abortion violated her due process rights. United States versus Nixon. The president does not have executive privilege in cases where he's done something illegal. Bowers versus Hardwick. A Georgia law classifying homosexual act as illegal sodomy was valid because there is no constitutional protected right to engage in homosexual sex. Immigration and Naturalization Services versus Chandler. Congress may not promote a statute granting to itself a legislative veto over the actions of the executive branch, which is inconsistent with the bicameralism principle of the Presentment Clause of the United States Constitution. Gregg versus Georgia. The imposition of the death penalty does not automatically violate the 8th and 14th Amendment. If the jury is furnished with standards to direct and limit the sentencing discretion, the jury's decision is subjected to meaningful appellate review. The death sentence may be constitutional. If, however, the death penalty is mandatory, such as there is no provision for mercy based on the characteristics of the offender, then it is unconstitutional. Solon versus Helen. The 8th Amendment's prohibition on cruel and unusual punishments prohibits not only barbaric punishments, but also sentences that are disproportionate to the crime. The Rehnquist Court. City of Bovine versus Flores. Enactment of the Religious Freedom Restoration Act of 1993 exceeded congressional power under Section 5 of the 14th Amendment. Kimmel versus Florida Board of Regents and the Board of Trustees of the University of Alabama versus Garrett. Private litigants cannot obtain monetary damages for the states for violations of the Age Discrimination Employment Act of 1965 or the Disability Act. Alden versus Maine. Article 1 of the United States Constitution does not provide Congress the ability to subject non-consenting states to private suits for damages in its own courts. The United States versus Lopez. Possession of a handgun near a school is not an economic activity that has substantial effect on interstate commerce. A law prohibiting guns near schools is a criminal statute that does not relate to commerce or any sort of economic activity. United States versus Morrison. Violence Against Women Act of 1994, 42 U.S.C. 13981 is unconstitutional as exceeding congressional power under the Commerce Clause and under the Section 5 of the 14th Amendment of the Constitution. Gonzalez versus Raich. Congress may ban the use of marijuana even where states approve of its use for medicinal purposes. South Dakota versus Dole. Congress may attach reasonable conditions to funds distributed to the states without running afoul of the 10th Amendment. Romer versus Evans. An amendment to the Colorado Constitution that prevents protected status under the law for homosexuals or bisexuals was struck down because it was not rationally related to a legitimate state interest. Lawrence versus Texas. A Texas law classifying consensual adult homosexual intercourse as illegal sodomy violated the privacy and liberty of adults to engage in private intimate conduct under the 14th Amendment. Alexander versus Sandoval. There is no private right of action to enforce disparate impact regulations promoted under Title VI of the Civil Rights Act of 1964. Lee versus Weissman. Including a clergy-led prayer with the events of a public high school graduation violates the Establishment Clause of the First Amendment. Zillman versus Simmons-Harris. School vouchers to provide religious schools is legal. Bigelow versus Commonwealth of Virginia. The First Amendment prevents states from prohibiting advertisements of clearly legal products or conduct. Muir Savings Bank versus Vinson. A claim of hostile environment sexual harassment is a form of sex discrimination that is actionable under Civil Rights Act of 1964, Title VII. The Roberts Courts, which is our current court, includes rulings such as Rumsfeld versus Forum for Academic and Institutional Rights. Because Congress could require law schools to provide equal access to military recruiters without violating the school's freedom of speech and association, the Third Circuit erred in holding that the Solomon Amendment likely violates the First Amendment. Georgia versus Randolph. In the circumstances here at issue, a physically present co-occupant's stated refusal to permit entry prevails in rendering the warrantless search unreasonable and invalid as to him. Jones versus Flowers. When the notice of a tax sale is returned unclaimed, the Fourth Amendment's guarantee of due process requires the state to take additional reasonable steps to contact the property owner before it can sell its property. Gonzalez versus Carhart, and upheld a ban on partial birth abortions. Parents involved in community schools versus Seattle School District No. 1. Racial quotas can only be used to establish equality if all other means have been exhausted. Morose versus Frederick. Because schools may take steps to safeguard those entrusted to their care from speech that can be regulated as encouraging legal drug use, The school official in this case did not violate the First Amendment by confiscating the pro-drug banner and suspending Frederick. United States versus Stevens. Depictions of animal cruelty are not, as class, categorically unprotected by the First Amendment. National Federation of Independent Business versus Velis upheld the American Health Care Act. As you can see, each one of the Chief Justices that I've just named in their rulings have a very specific character. If you go through and you look at these very closely, you can tell that each era of the court had its own motivations, its own things that it wanted to push. That's why who is on the court makes all the difference in the world. So what are the limits to the court's power? Well, it doesn't rule on political matters. It upholds precedent when possible, and it only deals with legal issues, not theoretical issues, as Antonin Scalia once said. The court deals with fact, not with science fiction. So what is the difference between a conservative versus a liberal in the court? Well, here are two links for you to look at. First one is Scalia's idea. This is an interview with Antonin Scalia on NPR. This is him saying that he believes the Constitution was dead, and therefore it shouldn't change, and its meaning and interpretation shouldn't change. Ginsburg's idea starts at 104 on the next video, and what it says is that it's not just about the words of the Constitution, it's about the ideas behind the Constitution. And therefore, a justice's idea is to protect rights, to protect the natural rights of individuals. So which is more important? Well, the truth is we need both in our ideas in our courts. We need liberals so that we can deal with new and different things that come up. But we need conservatives as well, because we need to be able to have consistency to our law. By having both these groups on our courts, it allows our law to actually change over time and meet our new needs, while at the same time giving us the consistency we need to have a good economy. All right, so what's selective incorporation? Well, remember that long list of cases that I went through? We talked about the Slaughterhouse case. The Slaughterhouse case had the effect of invalidating the 14th Amendment and allowed states to violate the Bill of Rights whenever they wanted to. Almost immediately when they issued the ruling, the court knew that it had made a wrong ruling and it wanted to fix it. However, it was right after the Civil War, and they knew if they reversed the ruling quickly, there would be a new civil war. So instead, they started giving rights back piecemeal as people sued for their rights back. So here's the test to see if you guys are actually watching the video. When was each right given back? And what rights have not been given back? Send me an email in Canvas. Send me a message in Canvas with this information. I'll give you 2 points on the test that you have this week. All right, so what about the makeup of the federal courts? Federal courts are made of 3 different levels: the district courts, the appellate courts, and the Supreme Court. In addition, there are special courts scattered all over the country that have special limited jurisdiction. District courts. The country is divided into 94 districts, each one having its own court. One judge hears a case, and a jury decides the case. More on this when we cover judicial policy later. It only has jurisdiction on federal crimes, constitutional questions, suits involving a difference in citizenship, and bankruptcy. Then we have the Court of Appeals. There are 13 courts that are found in the United States. Most important for passing rulings tend to be the 5th Court and the 9th Court. The 5th Court is the court for Texas. The 9th Court is the court for California. Appeals are granted based on whether the law was applied correctly in a trial or whether new evidence has been produced that would require a new trial. Appellate courts are overseen by 3 judges, and there is no jury for an appeal. Finally, we get to the SCOTUS, the Supreme Court of the United States. SCOTUS is a 9-panel judge. It has jurisdiction over cases that involve federal law, difference in citizenship, cases brought before the state Supreme Court, cases where there is a federal constitutional question, and cases where there's a disagreement among the appellate courts. So how do they choose cases? Well, one of the parties involved in the case has petitioned the court to hear it in a petition of writ of certiorari. The Solicitor General goes through each case petition and pulls out any cases that catches his eye. These are the cases that are brought before the justices. If 4 of the 9 agree that the case should be heard, then the petition of certiorari is granted and the court hears your case. The proceedings go like this. Before the court trial, all evidence is submitted in writing. No other evidence can be presented. The justices call on the lawyers representing both sides, and judges ask questions. The lawyers are only allowed to answer. The judges recess and vote the side with the most vote wins. But the important thing is not the ruling, but the opinion. Here we get into the majority, dissenting, and minority reports. Each side writes a report explaining why they voted the way they reported. The majority report becomes precedent. The minority report becomes the blueprint for overturning the ruling. And the dissenting opinions can be written by judges if they agree with the side, but voted that way for a different reason. Okay, so what about the special courts? These are courts like bankruptcy courts that only hear bankruptcy cases. The Court of Appeals for veterans claims, the Court of International Trade, the FISA court, the border courts. And the border courts have become more and more controversial as of lately. Here, for example, in revealnews.org, we have one of the problems that our border courts are currently having is people come over, they're sent back immediately. But what's going on is the Mexican police officers sometimes will flee into the United States when things become too hot and the cartels are trying to kill them and their children and their families. And then we send them right back across the border, right into the hands of the cartel, where they're immediately killed. Not saying this is a perfect thing, but we might think about some of the consequences of what we're doing. How are justices appointed? When making lower court appointments, the president asks for names from the governor of the state of the appointment is going to go, and the senators and the members of the House of Representatives. The appointments are then made to be traded as political favors for district court judges. The appellate court judges are not traded as often because they're more important stance for creating precedent. Remember, judicial appointments are lifetime appointments. A judge is your way to affect policy as president long after you leave office. So then the Senate ratifies the appointment after a hearing. So what about the Supreme Court justices? These are not traded, but they're made to influence policy from then on. Judges are chosen because their political beliefs match the president's. The state then either confirms or rejects the appointment based on beliefs of the Senate. Democratic president, Democratic Senate, you get more liberal justices. Republican president, Republican Senate, you get more conservative justices. If it's mixed, you get more moderate judges. However, sometimes judges are not conservative or liberal as their appointers thought. So what then do judges use to decide their cases? Well, they always use the Constitution. They use the letters written by our founding fathers at the time of the ratification to understand what they were thinking, including the Federalist Papers and the Anti-Federalist Papers. They use amicus curiae briefs, and they use precedent set in previous court decisions. Well, that is our wonderful world of the judiciary. I hope you enjoyed it. Go through, make sure you do your discussion, make sure you take your quiz, and make sure you take your test. Have a good day.